Oracle Corporation is an American computer company which filed suit against Google, an American technology company, for using parts of Java's application programming interfaces in their Android operating system, which Google claims they did under fair use. This is a case that goes back to at least 2010 and it has had various courts rule in favor of both parties. Each company has been overruled from Chapter 1 in various courts and appeal courts. In 2019, Google managed to get the Supreme Court to hear the case, but the hearing day has been pushed back because of COVID-19. The case the plaintiff, which is Oracle Corporation, is making is Oracle bought a company named Sun Microsystems that invented Java in the 1990s. Oracle bought them in 2009. Java is a programming language, and it's agreed that anybody is able to code with it. That's what code is for, basically.
So just like I'm going to put it out. So an API is a set of functions and procedures allowing the creation of applications that access the features or data of an operating system, application, or other server. So I'm going to be talking about that. So just thought I'd give the definition. So when Google was developing Android, they decided to make a developing code with Android OS to be compatible with Java to make our lives easier. So think of an API like a series of bridges. Clicking share article to Facebook from your Twitter isn't. So basically, there's 30 names that Google used for code functions that are same as the Javas and Oracle's as Javas. And Oracle is saying Google infringed their copyright even though Google's engineers wrote the code by themselves. So the case the defendant is making is that the code functions might be copyrightable, but they fall under the fair use. Here's an analogy made by Mashable to describe the situation. So say you're eating at a restaurant. There are items on the menu like burgers, fries, salad, and soda. You want to start your own restaurant across the street, but the original owner of the restaurant says you can't use those names for those food. Instead, you need to call your burgers a meat sandwich. For fair use, there was copying going on. The names are the same. However, the big thing that needs to be determined is if Google acted in good faith when using the names and did something different than Oracle with it.
So I am the prosecution, in this case, Oracle, and Kelly is the defense. Here are our cases. Back during Google's development of the Android operating system, they approached my client with an offer around $50 million to buy a license to use Java. The deal eventually fell through. They couldn't see eye to eye. The point is, we refused the licensing, and yet they went ahead and borrowed thousands of lines of Java code without a license or permission for commercial gain. This has ties with Chapter 10 key terms, intellectual property. On May 7th, 2012, a jury found the defense responsible for copyright infringement on a number of Java APIs, including the code, structures, and functions. The appeals court in 2014 found that my client's API resembled a taxonomy. That's two courts now that have ruled that the defense is indeed guilty of copyright infringement. The only defense Google has left to stand on is fair use from Chapter 10, and even then, the United States Court of Appeals for the Federal Circuit ruled in 2018 that Google's use of the API could not have possibly been fair use, as it is not. Java is an original and creative endeavor, and when 11,000 lines of code have been copied from Chapter 4, Burden of Proof, no matter if by hand or not, we must see that fair use doesn't apply here. The material has not been modified enough to make it their own.
I got the defense's case, and we are saying that a judge at the First District Court trial said of the Copyright Act, so long as the specific code used to implement a method is different, anyone is free under the Copyright Act to write his or her own code to carry out exactly the same function or specifications of any methods used in the Java API. It doesn't matter that the declaration of the method headliner lines are identical. My client was responsible for writing their own code. They did not sit there and copy and paste. They wrote the code entirely themselves. Yes, Google may be responsible for copyright, but the use of Java here falls under Chapter 10's fair use and Chapter 1's vague laws. There are multiple of open source programs and license codes that are alike. If the prosecution says that they can copyright and stop companies from using various APIs and different coding languages, then that opens the door for many different apps and companies to suddenly become in trouble. Linux is an open source. However, it was built using a copyrighted material. If that material were to suddenly be unavailable to everyone, then any company who has used it may be held liable, even if at the time it was an open source for everyone to use.
This is the prosecution rebuttal. The Copyright Act specifies as long as the specific code is different, and yet my client's work, numbering thousands of lines of code, has been stolen. The defense is responsible for hiring former Sun employees that worked with Java, and yet they claim that they don't know anything about it. Many open source projects require licenses to use. Just because they're open source does not mean that they're commercialized for everybody to use. It's not necessarily coding languages that are being copied, merely the APIs.
The defense rebuttal. Okay, we must recognize that de minimis is at play here. Yes, 11,000 lines of code were used, not copied, but used. And 11,000 might seem like a big number, but these operating systems and applications, they're millions of lines long. My client only used a tiny fraction of the original code. We offer the burden of proof from Chapter 4 that this is fair use. The Android operating system is an entirely different creation than Java and took a small portion of an existing idea to make something new entirely. This is a definition of fair use. Two appeal courts sided with Oracle, yes. The jury in the First District Court and in the jury in the United States Courts of Appeals for the Federal Circuit both have ruled that even if Google did violate copyright, they did not violate fair use.
This case is still ongoing, as it was pushed back from its initial March hearing date. If we were the jury, we would personally decide on Google as the victor. While they did technically violate copyright law, fair use is a vague and flexible law, and we feel that protects Google here. That's not really any creative, original ideas left, and copyrighting those that remain seems like a stifling creativity. Copyrighting code and API also could open the door to larger and more serious lawsuits down the line, as companies realize that they could restrict the freedom of developers and artists worldwide.